in terms of the approach that we take when handling these issues. Even in non-SEP cases, even in farmer litigations, there is a revocation that we file. And on the other hand, we are contemplating that the terms outlined in the FRAND agreement or in the licensing agreement is not on the FRAND basis. So on one side, at the CCI where they are filing a case, they are saying that the terms are not fair and non-discriminatory, and on the other side, we are actually challenging the validity of the patent in the true sense of it. So there has to be a consistency in approach. And even in pharma companies, we've seen that on one side there is a revocation or a pre-grant or a post-grant opposition that is being filed across, and on the other hand, we are contemplating licensing terms again. So on one hand, we do admittedly or implicitly admit that the validity of the patent is there, and on the other hand, we are challenging the validity in the true sense of it. So I think a lot of Indian companies need to think, because of the multiplicity of proceedings that Rajna was talking about, one proceeding in one jurisdiction or in one forum can very clearly impact in other forum when you're fighting a case or making arguments of the other level of arguments that you might have made across in another forum. So we need to be very consistent in our approach from that perspective. Also, when the matters go out to the CCI, we've essentially seen that when there's a writ petition filed across for the level of responsibility and the jurisdiction that the CCI has, there hasn't been a very clear education or very clear role and responsibility of the Director General, which has been outlined in terms of what powers he has to evaluate whether the terms are FRAND or not, or on various other issues based on which the entire complaint the CCI will file across. So I think in this particular year, when these suits by Ericsson and versus Micromax or Intex and other cases go up to high level of maturity, we will also hope to see more clarity on what cases and on what grounds can we actually file a complaint at the CCI, and what can we expect as far as orders from the DG are concerned. The third is that what we've also seen is that in a lot of these cases that are filed at the CCI, not only in IP cases but even in non-IP cases, because the CCI has the power to essentially investigate if the terms of an agreement are valid or not, or are they contrary to the public order. What we've also seen is that in IP cases, even in the Micromax case, one argument on the basis of which the complaint was filed was that the NDA that Ericsson had was very restrictive, that you had to keep it confidential for 10 years after the termination of the agreement and so on and so forth. So I think we will also hope to get more clarity on are these terms strong enough from an IP standpoint, or can we actually combine multiple issues in a single complaint, or should they be looked upon independently? Because the investigations would really depend on that, from a validity of patent or from a licensing term standpoint, or whether the terms in the NDA or various agreements that are involved in that litigation, are they all pertaining to unity of the litigation, or are there separate issues for which different complaints eventually should have been filed? Now, to answer the question that was posed across, what we've seen, I'm taking one position here, it is not consistent with probably everybody's position, but the position that I'm taking is that what we've seen in the last 6 to 8 months in our own experience as far as our litigation matters are concerned, is that ex parte injunctions are causing a lot of grievance to the defendants. And why I say that is one sample case what we did about 3-4 months back was where there was a claim which was filed across by, there was a suit which was filed across by the plaintiff where the matter related to a catheter or to a medical device for that matter, and they only had a US patent. That's about it. They did not have any design in India, they did not have any patent in India at all. And because they did not have any patent in India, there was a company in India which was, let us assume, copying their entire product and distributing here in India. And this company filed a suit claiming that this is infringement of their copyrights in the drawings of the patent. So, and obviously there was a senior counsel on one court, there was nobody on the other side, the matter was heard across. And the interim ex parte injunction stated that we do accept that the patent, the drawings of a patent application can have copyright protection. And which if you look at, in the whole sum defeats the entire purpose of the patent being there in the first place. Somebody could easily have his drawings posted on a website in the US, or on a website, or even file a US patent for that matter, and if drawings were to be given copyright protection for an industrial product like a catheter, then he could just have a US patent and keep suing companies all across the globe based on copyright infringement. And some forum or some way that the defendant gets an opportunity. And if there were discussions that were happening, if there was a legal notice that was given beforehand, and if the defendant replied or irrespective of his reply, this is not irreparable harm or perjury that is going to get caused across the plaintiff in this situation. So I think what we are seeing, there was another case, Live Technologies Corporation, I mean, we were not involved directly in it, but this case was filed across one day before the summer vacation was starting, which was 31st of May, 2011. And the matter, the ex parte injunction was given, and the matter was appealed, and the appeal, the division bench actually said that the matter will be referred back to the single bench judge. And there was some vacation for 2 months, and the matter went on. There were adjournments, there were all sorts of excuses, and it took 19 months to get the ex parte injunction carried out. 52 hearings is what it took to get the entire matter sorted out and at least get in. So I mean, it is so much of a. There might be a lot of cases where there is real harm, irreparable harm that is being done, but then we see a lot of cases where 10 days of notice or 5 days of notice or some opportunity can be given to the defendant to make his arguments, make his pleas, and have some sort of sustainability where there is a prudence which is done, especially in the cases where the copyright, when it was held by the single judge that there is copyright that subsists in the drawings of a patent. In these cases, and it took us almost about 2.5 to 3 months to get that, and we appealed, and the matter was referred back to single bench judge. Again, there was a reply filed in the application, and there were further exchange of documents, and then it was only after 3 months that we would get that located. So my answer to that question is that I feel that the standards on the basis of which ex parte injunctions should be given should be extremely high, because the consequences of getting them vacated are, they take months and months, and it obviously depends on the councils on board and many other parameters, but it is a big nuisance value. And if it is a trademark injunction which could 10 days would not harm you much, if that is the level of determination that can be made, I think that needs to be seriously looked upon. And Delhi High Court being a very IP friendly case, I think a lot of people find there are obviously jurisdictional issues in Delhi as well, where companies based out of Bombay and even the defendant is not based out of Delhi, but then still Delhi is chosen as the preferred level of jurisdiction. Probably, although you get decisions that there's a more matured set of judges here, who are more experienced in IP cases. But I think one more reason for sure is that you can easily get ex parte injunctions here in Delhi. So I think that probably is a factor that I wanted to highlight in discussion.
I'll go to Archana now. Archana, probably you can also add on, say something on the interior injunctions practice in India. At the same time, after saying something on the interior injunctions, I would like to really cover the next questions, round of questions within 5 minutes, because we are running out of time. So I request the next question you answer within 5 minutes. Particularly, how do you see the role of expert in the litigations in India? And if we can also cover what will be the effect or the future after the commercial courts are established and where IP litigations can be part of the commercial litigations.
I think I'll first comment on the on the interim injunctions. The way I mean, yes, I mean interim injunctions. It's not a rule. It's not that everybody is entitled to an interim injunction, and it's primarily the court's discretion or the judge's discretion whether a person's entitled or not entitled to an injunction, whether it's an ex parte injunction or it's a PI that's been granted after several hearings. Now the issue remains is how well have you been able to establish your case of infringement. It may be a patent infringement case. It could be an infringement case where there is a prima facie you can establish, just like for a new chemical entity in a pharma case, on looking at the drug, on the chemical structure, that there is a clear case of infringement. You could have cases like the telecom cases where injunctions were granted, but within a few days they were vacated but an interim arrangement was made. There are also cases where you might not have a patent, yet you're entitled to protection or you're entitled to injunctions based on copyright. And then maybe I just differ a bit from what Tarun said, because if we go back in history, in IEP, maybe particularly in patents, there hasn't been much of jurisprudence. With the kind of delays that we are having in India in terms of the backlog of not being able to enforce our patent till a patent is being granted, there has to be a fallback position. And the fallback position has been recognized by the courts in India in the John Brady case, where it's not for everything. Primarily, if you look at copyright infringement on the copyright drawings of a patent, there would be essentially for mechanical devices, like a catheter, or it could be an engine, and so on and so forth. So that's just kind of an alternate arrangement. So if you can demonstrate from the blueprint that it's a good case where it's absolutely a copy, there is no reason for the courts not to protect the creator of the innovation, merely because there are delays in court. Maybe that's not really the reason that the courts would. That's more an issue between the councils. That's a council where they have to really take care of ensuring that there are no more adjournments. They agree a settlement, that this is the date that we're going to argue this case out, and even get the judge to have a direction. So this is more an issue not to deal with whether an ex parte injunction. There can be no blanket saying that no ex parte injunction, no PI. In many jurisdictions, and I'm not going to kind of touch this upon in so much detail, we did talk about patent linkages in not being there in India. In many other jurisdictions, some way compensate, patent linkages have been in some way compensated by quiet actions. So if you do not get an injunction, you basically defeat the entire purpose of an interim injunction, which is based on balance of convenience. So if there's already something there in the market, there are issues of balance of convenience and irreparable harm which cannot be compensated, or which can be compensated by damages, which the court will certainly look at. So that's because I do represent innovator companies, but having kind of extensively studied the Indian jurisprudence and how it works in other jurisdictions, particularly in the US, I do feel that it is a case-to-case basis. There is no in the Roche case, which was the first case that went to trial, there was no interim injunction for many, many years. Even today, there is no, after the trial, and when in the appeal court, the division bench passed their order just last month, I think it was 27th of October, and it was November, 28th November. They still didn't grant an a permanent injunction after the trial was over. Why did they not grant? Because in this entire litigation, 9 years of the term of the patent were over, and only 6 months were left. So even at the final stage, the division bench came to a conclusion that give them costs. But I'm not granting them a permanent injunction. Leave apart an interim injunction. So again, it's not a rule that all cases will be entitled to. It's how good, and I think that's an art. How good or bad you present your case. What's the kind of evidence you place before the court? Whether it's a technical report for a non-pharma, even in a non-pharma case or a pharma case, it all depends on the kind of evidence that you need at the interim stage. It may be required, may not be required. Now, coming back to the second question on the role of experts in patent litigation. Over the last, I would say, I would just kind of, the cutoff date for me would be December 2015, and the year 2015 has been the year where there has been extensive discussion by the courts in India on the role of experts. So a success of a litigation is in today's world in India may not have been so extensively discussed in other, in the earlier cases. Depends on what is the kind of expert you choose. I think the main parameters that if I have to, if I kind of bring in all my, say, 25 years of experience to this table to say, how would you decide your experts? You decide your expert at what stage of litigation you are. Are you at the interim stage or are you at the permanent stage? At the interim stage, if it's a new chemical entity in a pharma case, you can establish it just by showing the structure, by the INNA. If it is a telecom related or a non-pharma related, like a medical device, do you need a technical report? It may not be an affidavit. It doesn't have to be it can just be a report of an expert saying that I've evaluated this device and I have read this patent and I believe that this reads upon the claims. The second critical factor that would determine on your selection of, and I'll come to the case laws, where these issues have been dealt with because we have little time, is on the nature of technology that's involved. It's very critical when you're deciding on the expert is what is the kind of technology you have. Do you need it? Do you need it at that stage or you do not need it at that stage? So it could be pharma and non-pharma if I have to divide that. Within the pharma, is it a new chemical entity or is it a formulation? Because if you're going for a quiet limit action in anticipation of the launch of the product, and if it's a secondary patent, not a composition of matter patent, and there's no release, the infringing product is not out in the market, how would you conduct an infringement analysis? That's a big question. I think that then the next level would be, at which forum are you when you have to decide your expert? Are you before the Intellectual Property Appellate Court? Are you before an invalidation action before the IPAB, where you rarely get a judge? If you're before the Patent Office, obviously, your expert evidence has to be of the highest quality. It can go into pages and pages, but it has to be of the highest quality. Why? And I have reason for it. I would imagine, unlike the court proceedings, where you see a trial and there's a deposition, or there's a cross-examination that happens, that benefit you don't get that benefit before the Patent Office, because it's all based on what the expert has said and how that's going to be articulated when you are doing your oral arguments. So you may have an expert who talks about, an independent expert. You could have the inventor who talks about the challenges when that led to the development that he faced while developing the invention. You would have somebody who talks about the commercial success of the drug. An independent person, maybe an economist who talks about the commercial success. But when you come to litigation, again, in a litigation you do talk about, you have an expert, an independent expert. You may have an independent, you may have the inventors being an expert. You would have a person who establishes fact of infringement, which would be a company person. And maybe also you might want to, when you are trying to claim damages, you might want to have a report of an economist who says, what would he say that this is the kind of, if I have to look at the damages, he starts kind of valuing the patent and the kind of commercial success that has seen and calculates damages. Now, pretty much I've seen in the US litigation, the cases that I've kind of gone through, is that when you are dealing with damages or kind of computing damages in these litigations, you try and exclude the commercial success or the damages that are a direct outcome of the advertising spent on that commercial product, on that product that comes out of that patent. Now, going back to what the scene is in India with regard to experts, I think if I have to kind of pick up 5 cases, there have been only 5 cases in 2015 that have extensively spoken about experts, and the rise and the fall of litigation has been based on what were the kind of experts that the plaintiffs and defendants chose. Before I go into that, I think I would imagine that today when we are, I would say experimenting, we are trying to develop the IP jurisprudence in the country and have kind of brought in some great concepts that have been adopted, say for instance in Australia. So we had this Aventis case before the Delhi High Court at the interim stage. There's a very unique concept which evolved in Australia, which is known as the hot tubbing concept, where you get experts you get independent experts, one from plaintiff and you get one from the defendant side, and you ask them, to give their scientific report on a very limited purpose. So that's a concept that's been still explored by the Delhi High Court in the Aventis. We've got experts appointed from both sides, independent at the interim stage by the court. You have the other extreme where you have scientific advisors that have been appointed by the courts from the institutes like IISc and IIT, which assist the court under the provisions of the Patents Act. You have a 115 provision which assists the court in explaining the technology. So it's got to do only with the technology. I think at the other end we have these 5 cases. I think the first case I would kind of put it on the very, very high pedestal would be the Merck versus Glenmark case, because this is actually the landmark decision of the year 2015. It's after 45 years in the history of patent law that an innovator company was given a permanent injunction after a trial. So when we do talk of, I mean, that's going to be a bit off track, but when I do talk about the Merck and Glenmark case, we talk about the delays. We have 2 things before us. We have the new Commercial Code Act, which ensures that your entire IP litigation is finished within 12 months. If you even stretch it, it will go maybe to 16, 17, or maybe 2 years. And then we have an order like the Merck versus Glenmark case of the Supreme Court, and that's where it all came in from, when the Supreme Court said that IP litigation is indeed a commercial litigation. And if it's going to be a commercial litigation in the national interest, all these kinds of litigations have to be expedited. And in a record time, I would say like 5 months, the entire trial of 8 witnesses, Indian and foreign, plaintiffs and defendants, cross-examination, depositions, filing of affidavits, and complete arguments, with the order was done in 5 months. So we started our arguments from April, we started in April from the Supreme Court, and we had the order in October. So that's the kind of the timelines that we are really looking at when we're talking of IP litigation in the country. Now, coming back to the role of experts, I mean, for those who have who've had a chance to go through that decision, I cannot go into the kind of the granular details of that decision. But the success of that litigation has been on 2 experts of the plaintiff. One is the independent expert of the plaintiff, extremely high quality, and the other was the inventor's affidavit. So the selection of your experts is critical. Try doing it right at the beginning when you start your litigation, because don't lose out time in trying to identify an expert, because you might need an expert for different aspects of the litigation. Then we had the Roche versus Cipla case, which was a division bench. Again, extensively experts were, the deposition and experts was relied on. Then from the Bombay High Court, we had the CTR case that's been there for many, many years. Justice Patel kind of gave a very good order. Again, the role of experts, that how did the expert prove infringement or non-infringement, as the case may be. It's at the interim stage. So the Roche and the Merck are at the final stages, they were the final orders, but the CTR case is the interim stage. You have the Ringo case. Now the Ringo case, interestingly, it came as pretty much as a shock when at the interim stage, the single judge said that the expert that the plaintiffs had filed was not a credible affidavit, for the reason that he did not have any, did not have any degree or experience in that area of technology to which the patent relates. And pretty much the single judge did say that, he kind of related the qualifications of a scientific advisor to that of an expert, which was maybe, according to me, was incorrect.